These are 5 things you must carefully review before you ink your signature on the contract: the pay, the malpractice insurance, termination and renewal, the non-compete clause, shift schedule and duties, and I will add a 6th one as a bonus, the indemnification at the end. Watch to the end. This video is extremely important and I'm going to teach you how to review them so no regret later. Please forgive me as I will shift to these non-clinical job related extremely important videos for the next 1 to 2 videos. Nobody taught us anything about this during medical school or residency. Let's start. The pay, there are a lot of important details about the pay we need to know and understand so we can make the most money from the employer. For that reason, I'm going to skip the pay today and dedicate the next video just to the pay details. Don't miss that video and subscribe to the channel now and hit the notification bell so you get notified about that video as soon as it's released. Let's move to malpractice insurance. In your contract, it should be clearly mentioned the employer will provide you with a paid medical malpractice insurance policy, specifying the type of the policy and the amount of coverage. There are 2 types of malpractice insurance policy in USA. The first type is occurrence mode policy. The policy here covers any litigation or lawsuits for incidents that occur while you are under contract, regardless of whether at the time of the complaint you are still with the employer you had the incident with or have moved to a new employer or practice. The second type is the claim mode policy. The policy here covers lawsuits and litigations for incidents that occur while you are under contract, but only if you are still at the time of the complaint with the same employer. Let me give you an example to clarify this. You worked for employer A from January 2018 to June 2022. You received a complaint against you from a patient regarding an incident that happened in May 22. If employer A offered you an occurrence mode policy, then you will be covered with the policy despite you are no longer with them. But if they offered you a claim mode policy, this complaint will not be covered by the policy as you are no longer with them. Remember that lawsuits and litigation can be filed up to 3 years after the incident. For that reason, with claim mode policies, you will need something called a tail coverage policy to cover any possible litigations and lawsuits after you are no longer with that employer. This policy should be offered for 3 years from the day you leave your employer. So a paid tail coverage policy is required if your employers offer a claim mode policy only, and that should be mentioned in the contract. You will not need that with an occurrence mode policy. Now, each malpractice policy will provide coverage to a certain limit, and this is usually represented by 2 numbers you will see on the policy. Let's say the policy will cover 200,000/600,000. The first number represents the total amount that an insurance carrier will pay on behalf of their clients for any one claim. The second number represents the total amount an insurance carrier will pay for all claims within a single calendar year. So the above numbers means that the insurance carrier will pay up to $200K per claim and up to $600K for all the claims within the same calendar year. The standard of the coverage amounts varies based on the location of your practice as state laws are different. So ask about the standard coverage of your area and make sure your policy meet the minimum standard. And all of that should be mentioned clearly in the contract. Let's move to the renewal and termination clauses. Most hospitalist job contracts are issued on 1-year terms and are typically automatically renewed under the same terms and conditions in effect at the end of the initial term for successive 1-year term unless sooner terminated by either party. So if you want to add or amend your contract, you must do so before the automatic renewal date, as you will need to sign a new contract. How about termination? Termination of the job contract can be triggered in different ways. First, termination by mutual consent without prior notice, and this should be okay as long as it requires mutual consent. Second, optional termination at the discretion of either party with prior notice. Here, you or the employer holds the right to terminate the contract unilaterally. The termination will become effective only after the prior notice period, which is predefined in the contract. Aiming for a prior notice period of not less than 2 months but not exceeding 3 months will be good. This will grant you a cushion transition phase while you're looking into your next move, and at the same time not to stay long in a place you don't feel you belong to, especially if you are the one who hands his or her resignation. The third one, termination for breach. Here is the contract is terminated due a breach in the agreement from either party. Here, both parties should be furnished with a written notice of the violation of the agreement prior to the termination taking effect, usually within a time frame of 2 to 3 weeks. So ensure to have this clearly predefined in the contract. You do not want to be terminated for a violation without knowing about it at all. And the last one is the immediate termination by the employer. Please carefully review the terms under the sections in your contract, as this section should be only triggered if a serious violation occurs, like committing a crime, losing your license, or maybe the physician becomes uninsurable at standard rates for malpractice insurance, etc. of course. So please review this. You want to make sure that only serious violations are included under this section. Let's move to the non-compete clause, which is a clause in employment contract that prevents worker from working for competitors. In the healthcare field, the non-compete clause are used to ban physicians from leaving their employer and setting up a competing practice nearby or working for a local competitor. This clause will often be defined for a specific period of time and a certain distance from your current employer's location. For example, they may restrict you from working with any competitor or opening your own practice for 3 years and within a 100-mile radius from your job location. California, Minnesota, North Dakota, and Oklahoma have banned non-compete agreements entirely, and many other states put some restrictions, so familiarize yourself with your state or your local state laws. This is an important clause to review if you are thinking of working some extra shifts locally. For full-time employees, this may be acceptable, but if you are a part-time employee or working as an independent contractor or locum tenens, ensure there is no non-compete clause in your contract, as you want to be free to pick up shifts anywhere. Let's move to shift schedules and duties. Most hospitalist programs follow 12-hour shift length. Some opt for the 8-hour shift, and the length of the shift will determine the minimum monthly number of shifts you are required to work. The 12-hour shifts mean your minimum monthly number of shifts is going to be less compared to the 8-hour shift. Full-time hospitalists are required to work a minimum of 14 to 16 12-hour shifts a month, which is translated into around 180 shifts per year. Part-time hospitalists are required to work a minimum of 7 12-hour shifts a month, which is translated into around 84 shifts a year. For independent contractors or locum tenens, it depends on what you agree upon. Personally, I request to have no shift commitment, which means I pick and choose if I want to work that month or not to work at all. Remember, these are minimum shift requirements, which means you can work more if you want. Confirm it's clearly defined in your contract, as you do not want to be forced or pulled out to work extra shifts. It should be an optional thing. Hospital schedule in most cases is on a week on, week off basis. Now, that's been said, I've always preferred, when I was still a full-time hospitalist, to rather have a flexible schedule instead of the rigid week on, week off schedule. My contract back then stated week on, week off schedule, but as a program, we agreed to have a flexible schedule so we can accommodate our personal needs for longer time off if needed. If you are a day person and do not want to work night shifts, you better have them mention it in your contract, so they cannot pull you for night shifts coverage without your permission. Also, if you are promised you are going to work in one location only, it's better also to include that in the contract as well, so they do not pull you to cover in other locations without your will. Let's move to the bonus item, the indemnification, a legal term we must understand so it doesn't get sneaked into our contract. Indemnify means to promise to financially compensate or protect someone if they suffer a loss, damage, or legal liability. Nothing better than an example to explain this legal term. Imagine you are renting a car. When you rent the car, the rental company might offer you insurance for an additional fee. If you choose not to buy the insurance, the rental agreement might include a clause that say you agree to indemnify the rental company. Now, let's say during your rental period, you accidentally scratch the car paints while parking. Since you did not buy the rental company insurance, you would be responsible for the cost of repairing the scratch. In this case, indemnify means that you promise to cover the expenses of fixing the scratch and you are financially responsible for the damage you caused. Now, in healthcare, for physicians, indemnification is better completely avoided for us, and if mentioned in our contract, we must carefully review that. And there are two ways the indemnification typically mentioned in the contract. We either indemnify the employer or the employer indemnify us. There is no problem with the employer to indemnify us, but every time you read the phrase physician shall indemnify and hold harmless employer, you need to get worried and try to eliminate it from the contract if possible. If that's not possible, make sure you understand the circumstances in which you may indemnify the employer. I remember one of my colleagues was deposed in a malpractice case against another physician and the organization he worked for at the time. Few months later, he received a letter from the organization asking him to pay for damages as his deposition did not help them with the case. So you want to be careful about indemnification in your contract. In the end, the best indemnification clause is a deleted indemnification clause. I hope you found this video useful, and if you did, share it with your colleagues, give it a like, and I'll see you next video, the pay terms. Thanks for watching.